Welcome back to Cordell and Cordell's live broadcast webinar on COVID-19 and its effect and continuing effect on custodial rights for guys, divorce, child support, alimony, enforcement of visitation, paternity we're going to talk about today, you name it, everything before, during, and after divorce and related to family law. I'm Scott Trout, CEO and Managing Partner of Cordell and Cordell, and welcome back to our third part of this series that continues. We bring you some of the top attorneys from around the country at Cordell and Cordell to bring you kind of boots on the ground, the latest tips, things that you need to hear. And remember to ask and answer the questions of what can I do, what should I do, and what must I do. So as we continue this series, keep in mind that I want you to continue to submit the questions that you have from around the world at coronavirus.divorce@cordelllaw.com. Again, coronavirus.divorce@cordelllaw.com. We'll address some of those questions today as we have for the past 2 weeks, but more importantly, I now have a daily podcast devoted to just answering some of these questions to make sure that we get to as many as we can. In addition, you'll find some of the podcasts where we take specific issues related to men before, during, and after divorce. You can find that on the Men's Divorce Source and also on YouTube by going to cordellcordell.com. So today is a little bit different. We're going to have, again, 4 panelists and some of the top attorneys from around the country at Cordell and Cordell, but we will take a break later on and bring 2 more. So we'll have 6 attorneys from Cordell and Cordell joining you today to bring you the latest information and some tips as you face this crisis in COVID-19. So before we get started though, again, the disclaimer that I always bring to you, and that is this should not be taken as legal advice nor the attorney-client relationship. I say this every week as well as in my podcasts. This is really designed to give you some information, an educational tool so that you can go to your attorney or call us and ask us questions. It's really to stimulate a conversation as you continue to face this crisis that is ongoing. So keep that in mind throughout, because I'm only licensed in Missouri, Illinois, and Georgia, and the guests that I have today from around the country are licensed, for example, in California, in Florida, in Arizona, in Georgia, and in Maryland. And so keep in mind that they cannot give you legal advice. Your specific set of circumstances do matter. So it's so important, especially now, to have that conversation with an attorney. And that's what this is designed to do, is to stimulate that thought process for you. Before we get to the panelists, one of the things that often comes up is, are we open? What can I do? I mean, I've heard shelter in place. I've heard the world is closed, right? Including we have viewers from the UK and our offices in London. But the answer really is, at Cordell and Cordell, we're still open to the extent that we can be. We're taking consultations telephonically, virtually, via video conference, and where we can and at the request of clients, if they want, obviously in person. Things don't stop. Divorce doesn't end at 5 p.m., doesn't begin at 9 a.m. It's 24 hours a day, 7 days a week. We're still here to serve you. And that's critically important because, as you'll hear today, as you did last week, there are certain elements that are going to require you to take action. We got bad news today with another over 6 million unemployment claims. That brings us almost to 17 million people out there that are really suffering in this economic crisis. And I know that for you watching, many of you are in that number. We're probably looking at 4 to 8 million guys out there that are really trying to ask the question is, how do I pay my child support? How do I pay my alimony? I'm not seeing my children. What do I do? Well, hopefully we'll address some of those concerns for you. And one of the unique things that we're rolling out at Cordell and Cordell to really address this crisis for many guys out there facing the critical decision of how do I make my child support payments is that we're trying to answer that age-old question, and that is, how much in attorney's fees will this cost me? Many firms can't or wouldn't answer that question. Well, now in many of the states around the country at Cordell, we will answer that question. For those guys facing a child support modification, they need to do it. We're going to find that answer and we're going to give you a number and we're going to say that's the most you'll ever pay in attorney's fees. If it winds up being less, great. If it winds up being more, you don't pay it. So that's what we're going to roll out. We think it's going to be a tremendous relief to many to have some certainty, to know the budget, to know what they can spend on attorney's fees, at least at the most, so they know what is expected moving forward. So we were excited about that. If you want more information and details, if it's available to you in your state, please reach out to us You can go visit us at CordellCordell.com or call us at 866-DADS-LAW, schedule that consultation, and we'll make sure to get you the latest and really talk to you about that really special program during this crisis. So let's get right to it and talk to you about the attorneys and introduce them to you again during this COVID crisis. Starting off, we want to introduce to you someone coming back from California, Jason Hopper. Jason, welcome back.
Hey, Scott, thanks for having me back here on the West Coast. I've been attorney with Cordell Cordell for over a decade and have had the pleasure of practicing domestic relations going on my 13th year of practice. I'm licensed here in California as well as the state of Indiana and am a member of the United States Supreme Court Bar.
Thanks, Jason. Glad to have you back and get some perspective from the West Coast. And kind of going along that, we wanted to get you some information for those in Arizona. Tali Collins, welcome. Introduce yourself.
Hi, glad to be here. My name is Tali Collins. I'm the litigation manager in Arizona. I've been with the firm for 5 years now, practicing exclusively in family law for 11. And I'm currently appointed as a judge pro tem for the Minnesota Superior Court here. So thanks for having me.
Thanks, Tali. Going back up to the East Coast for the first time, joining us in our Boston, Massachusetts office, a litigation partner with Cordell & Cordell, Andy Ordina-Pimentel. Andy, welcome.
Hi, Scott. How you doing? I'm glad to be with you today. I've been practicing for just under 19 years. I've been with the firm for about 13 years. My practice is exclusively in domestic law, and I'm also licensed in New Hampshire and Georgia.
Thanks, Andy. Welcome. And rounding out the panel for this segment, keep in mind that we will take a break, a very brief break, to bring in our final two panelists somewhere around the middle of this afternoon. But joining us now is Kumara Chandran from Baltimore, Maryland. Kumara, welcome.
Hi, everyone. I'm Kumara Chandran. I work at the Baltimore office of Cordell & Cordell. I have been licensed for 7 years, and I've been with the firm for 2. This year, I was fortunate enough to be an honoree of the Maryland Daily Records Leadership in Law Award.
Thanks, Kumara. We're excited to have you and have you join us now, and we can kind of take it off with you as we talk a little bit about one of the most pressing issues for guys. A lot of the guys right now found themselves in the middle of their divorce, or they were right at the end of their divorce set for trial, and then COVID-19 hit, and like a domino, most of the courts began to stop having in-person hearings, not necessarily closed, but maybe you can talk a little bit. Are the courts closed in Maryland? If guys had already been filed, are they closed to hearings right now?
In Maryland, they are closed to hearings. There's only specific hearings that they are allowing. That's emergency hearings and domestic violence hearings. And again, this is really limited in family law to just things in which people are in a substantial risk of harm.
So Kumara, with guys facing divorce and they're in the middle of it, many think that everything should stop and that they shouldn't call their lawyer and they shouldn't take action. Is that really something they should be thinking about? Because what comes to mind for me is discovery. And I imagine that you would recommend that they continue down the process of discovery. And we use that term, maybe answer that question, but also just tell them generally, high level, what discovery is and why it's important right now in the middle of their divorce.
Sure. So discovery is really exchanging evidence with your wife or your child's mother's attorney. So there are many tools and they are very reliant on your participation and your working with your attorney. There's written tools. We have interrogatories and requests for admissions of fact. Those are very common. And in terms of the other tools, we have request for production of documents, which is just that, getting documents. We have depositions, and your attorney can also subpoena evidence.
So you mentioned interrogatories. We often throw these words around, and clients don't necessarily understand unless they're in the office and we explain to them. Tell guys right now what interrogatories are, number one, and why they're important, and they should go to their lawyer now and say, let's do those.
So interrogatories are essentially questions you answer under oath. And these are questions that your wife or child's mother's attorney has given to you to answer. What I usually ask my clients to do is, write out their responses and be as detailed as possible, make sure you answer all the questions. People forget how time consuming this really is. And the important part about interrogatories is that you can use it, especially when we propound it to the other side, you can use it to challenge somebody's credibility on the stand at trial. So I always make sure my clients send out discovery requests, and we also respond thoroughly.
So I look at it as an opportunity to kind of put them in a corner in terms of their answers. And I assume that's what interrogatories do. And you can use that to cross-examine them when you get to court, and when courts open back up. I just see it as a great opportunity to what I call frame the issues, frame their responses. Would you agree?
Yes, definitely. I think that it's helpful in two ways. Like when I say credibility, I mean, if your former significant other is, you think that they're going to lie on the stand about something, this is something in which in cross-examination, you can really corner them in, make sure that your attorney is aware of the false statements that they're making, if they've made it in the past, or if there's, a way we can challenge it in cross-examination. So even your input, if you read over the other responses from the opposing party, that's helpful as well.
So let me go out and throw it out to Arizona with Tali Collins. Hey, Tali, out in Arizona, first of all, are the courts open? And second of all, just keeping along the lines of trying to keep the case moving forward for guys, maybe you can talk a little bit about depositions and why they're important and what they are, and why guys should be calling their lawyer to maybe do that right now.
Yeah, so our courts are definitely open. A lot of the in-person hearings have actually been moved to telephonic. The final hearings, though, are being continued. So quite a few of them are being pushed out 2, 3, or some of them are still waiting to be reset. We are able to do emergency hearings or orders of protection. Those are done in person right now. So as far as moving the case forward, I've had this question a lot lately. How do we move this forward while we're kind of in this, this confusing time? So I've had my clients do a lot of disclosure. So collect those financials, get those bank statements, tax returns, all of that. And to your question about depositions, this is a really good time. A deposition is a good opportunity to ask the other side questions that are related to the divorce or the matter. It again nails down their positions. That should help you either in terms of settlement or for final trial whenever that gets set.
So Tali, can depositions be done via video conference right now? Because typically, prior to this, you'd have everyone, all 4 people, and a court reporter in the office answering questions. Can that be done just via video conference? And if so, can it be scheduled during this crisis?
Yes, they can definitely be scheduled during this crisis. This is a good time. Well, not a lot of other stuff is maybe moving forward that we can do that. And yes, they are being done through Zoom or some other teleconference method. The court reporters are really good in helping us coordinate that and figure that out, so we can use that as a resource at this time.
Great. Let me throw it out, Andy, up in Boston and Massachusetts. Same kind of question. Tell everybody what the status of the courts are, whether things can proceed, you can file, whether they're emergency hearings. But then lastly, there's something called a request for admissions. Maybe you can tell guys why that's important. It's often overlooked, rarely seen in family law cases around the country, but something that we do, and I think is really, really important to consider. Maybe you can talk a little bit about that.
All righty. So the courts in Massachusetts are closed except for emergency matters such as restraining orders. Otherwise, you're just not going to get in. The clerk's offices, however, are accepting pleadings. So I have cases that need modification actions and alimony and child support. I'm getting those filed right now and having them set for hearing hopefully in May. With regard to requests for admissions, those are very powerful tools in that you can have your attorney say, please admit that your name is a good client. Please admit that you withheld the child from your the father on X date. Any number of just as many statements as possible. There's no limit on the number of statements you can put in this request for admission. And what your wife or ex-spouse has to do is they have to either admit or deny the statement as written. And then they have to sign it under penalty of perjury. And that, again, is a way to discredit them in court if they lie. But the most powerful thing about a request for admission is that there is a deadline for a response of 30 days. And if your wife or your ex-spouse does not respond within 30 days, every single statement in that request for admission is deemed admitted. So it can be a very powerful tool. The rules and the deadlines to respond have not been suspended. So get your attorney to send those out on some of the most pressing matters in your case right now, and you can put the other side under the gun on time.
So Kumita, just kind of following up, great Andy, on this request for admissions, I imagine now more than ever. If guys are being denied custody, being denied visitation for whatever reasons, that would be something you would want to ask. Please admit that John was denied custody on March 27th, 28th, 29th. Get him to admit, and then please admit that it was done without valid excuse or without unrelated to health issues. I imagine that would be something important and admissible, especially in Maryland.
It's extremely important. In Maryland, we have also an unlimited amount of requests for admissions that we can do. And again, I know I mentioned earlier credibility, the importance of making sure, showing the court that your former spouse is essentially lying to the court is really important. I mean, because it is family law, I've won and lost cases based on credibility alone. And I've even had a judge say, if there's no custody evaluation, there's no experts in your case, the judge isn't going to come into your house. They're never going to see your children. So really, they have to rely a lot on what he says versus what she says. And that's when credibility comes into play. And what's great about the request for admissions of fact is you really can get your client involved. I have had a client actually send me a list of things that he really wanted to make sure was included. I obviously, narrowed it down and, did what I could, but it was so helpful because there are so many things I don't know, it's not just a judge. Like I usually don't ever see my client's kids. Like there are so many things I don't know about your life and what's going on. So it also keeps me, if I'm your lawyer, informed about things I may not have heard of. And one thing I always tell my clients is, I don't want to hear anything new from in the stand. That's not the time to tell me new facts about your case. So this is a really good way also to keep your lawyer informed of what's happened.
Yeah, I think it's extremely important, and albeit things shut down or slow down, it's really in this, what I'll call a quiet time where you're not distracted by other cases that are in court or you have trials. You really can focus on even furthering settlement discussions. Maybe talk a little bit about what guys should be thinking about, maybe preparing an offer, having a conversation, talking to their attorney about proposing something or even informally mediating.
Sure. So mediating is actually a good tool right now because there are private mediators, other attorneys that you and your wife or your wife and your wife's attorney and whoever your attorney is, can agree upon private mediators who can do things virtually. So mediation is a good tool. Mediation is really having a third party neutral try to get you guys to settle the case. And with regards to settlement, this is a really good time to start discussing settlement because, here in Maryland, the courts are closed till May 6th. So, if your hearing was canceled, we don't know when it's going to get rescheduled. The courts could stay closed longer. We don't really know. So even if you're just, even if you and your ex-wife are very, very far apart, there are smaller issues that you can come to an agreement on, and that would actually make it easier and make for a shorter trial, less time in a hearing. Things that you can agree on that people typically can agree on, things like legal custody, who makes decisions for medical care, education, religious upbringing for the child. Typically, people are jointly making this decision, and joint legal custody is very typical. Another thing is sort of putting up a holiday schedule, just little minor things that you guys could agree upon, times you can phone the kids, things like that. At least try and narrow the issues in your case. And if you can get, at least child support resolved, or at least alimony resolved, or even just legal custody resolved, that's gonna decrease your time in court, and it's gonna make it easier for the court to put in your case sooner than later when you're saying your hearing is gonna be a shorter amount of time.
That's a great points in terms of really getting things resolved, because imagine the backlog that's coming to every state across the country. It's going to be really difficult to kind of get timely hearings held, because we're not even counting the cases that have yet to be filed. So thanks, Kumita, for all that. Hey, Jason, let's talk about some of the other pressing issues that we get questions on often, and that is visitation. One of the questions that was submitted last week was, can they deny visitation when their ex has showing symptoms of COVID, but not necessarily tested positive, and they're concerned about the health of their child, that they've got them during a period of custody? Can they just deny them some custody, or really what should they do? Maybe that's the best question.
Sure, Scott. So, to best answer that question, it's really going to vary on a case-by-case basis. And really, probably what's most important is know your judge and know your jurisdiction. And if you don't know your judge or your jurisdiction, then consult with an attorney who does. First and foremost, the thing that I would look at is, has your county or your jurisdiction issued any type of an advisory opinion or standing emergency orders? In California, many of our counties have, and in large part in the counties that I practice in, they are mirroring the content of some recommendations that were issued in mid-March by the Association of Family and Conciliation Courts. In large part, the recommendations are that visitation is to be facilitated unless there's an intervening order. Now, we've talked in weeks prior about the fact that there are emergency options and emergency relief that might be available to you, but in a situation to where there's a concern that there is exposure, but we don't necessarily have confirmation of that, and we don't want to be accused of being the boy who cried wolf. We might want to consider some other options, some other practical solutions that might be available to you, short of seeking that emergency relief. Yeah. One practical thing that I've just started incorporating in my practice just in the past week or two is consider if your child has a pediatrician who offers online consultation, or with my children, my children's pediatrician offers an app where we can log in and ask questions. If there's a disagreement between yourself and your co-parent as to how you're going to handle the ongoing visitation arrangements, it's a perfect opportunity to seek the advice of a medical professional. You can likely get some sort of same-day feedback from your medical professional. Another resource that might be available to you outside of seeking emergent court intervention would be to make a call to the Department of Child and Family Services. They deal with health and safety and welfare issues of a child. Certainly, you want to consider your options as to emergency relief. It is available to you, but it's going to vary on a case-by-case basis. That's why we think it's really important to come in and consult with us. As you mentioned earlier, Scott, we have all these virtual and phone appointments readily available. It's very case-specific as to what the action plan might be for your case, but really how you deal and how you operate and conduct yourself in this time of crisis really can score a lot of points down the road when you find yourself in front of litigation.
So really, some of the things that guys are facing, and you can imagine, especially in California, where perhaps pockets in California have more restrictions in terms of the shelter in place, but guys are asking the question about their spouse or their ex is traveling during this, and maybe they're not even following the shelter in place guidelines. What can guys do? What should they be doing? Is there any emergency relief that they could be filing? Should they be communicating with their spouse? And then lastly, what should they be doing to get something in writing, right? To kind of put it on record of their objection.
Yeah, so in California, almost every county has a local rule which requires what we call meeting per efforts. In a lot of instances where we have existing orders, those orders incorporate requirements of online parenting apps like Our Family Wizard, things of that nature. And if we don't have that in place, then certainly communicating through email. So I would suggest that that with the ongoing pandemic, this is a really an instance where you want to over document your concerns. Weigh out in indications to your opposing party what your concerns are in line with the CDC recommendations. If we have a situation where the existing order might call for air travel, state your concerns. Go over the competing factors with your opposing party. You might not reach an agreement, but if you're stating out the pros and cons regarding the health and safety of your child, and then you ultimately seek out emergency relief of the courts, you can document and attach that as part of your emergent relief. In the instances where we have sought out emergency relief in the past few weeks, most courts are conducting these proceedings based off of what's on the written document, and they're not really offering the opportunity to come into court or even appear over the phone to offer oral argument. So making attachments of your efforts, of your prior efforts, that really can win the day for you if you find yourself in a situation where you have a very urgent health and safety concern for your child through air travel or otherwise.
Thanks, Jason. So Tali, we talk a lot about divorce, and we talk a lot about guys thinking about divorce, going through a divorce, and they have a decree. But what we haven't talked about yet for the last 2 weeks is guys out there who have kids, they've never been married, and they have no court order, what we refer to in the legal world as paternity. And those are the guys that I think have the most difficult time right now, because what I explain to clients is you really don't have any legal rights. And their response is, well, I'm on the birth certificate. Maybe you can kind of just generally talk to guys about what that means. Does that give them any rights, and why they should be trying to file for paternity right now, and what that would do for them in a crisis like this?
Absolutely. So without being married in Arizona, so fathers have no legal rights. So we need them to be paternity to be established, and we need a parenting plan. So there's my recommendation is to be proactive rather than reactive. So right now, if parents aren't married, the mom can kind of control what happens with that child, whether that's travel, whether that's parenting time for dad, what's actually going on. So my recommendation is to file a petition to establish paternity, legal decision making, and parenting time. That gives you at least a foot in the door. So if the mom, for some reason, does start denying parenting time, making it frustrating, doing something that you don't think is in your child's best interest, you could file some of that, the emergency relief or some temporary orders that Jason was referring. We have those opportunities in Arizona as well. And the courts are allowing those types of issues to be heard on a more expedited basis. A lot of those are done telephonically right now. And so I think that's important. That's an important step to do. Realistically, dads that don't have legal decision making or parenting plan already need that to happen. We need court orders to be enforced and followed. And those are going to be helpful just moving forward. So, a mom can't really prevent having parenting time or contacting the children.
So many guys are just saying, but I'm on the birth certificate, Tali. Doesn't that let me, I'll call the sheriff or I'll call the police. And, I was seeing my child regularly, but now mom's just not taking my calls. Isn't that enough to be on the birth certificate?
Unfortunately, in Arizona, it's not enough. So we need not only the birth certificate and paternity to be established, we also need that parenting plan. Until those two things have happened in Arizona, the mom has sole legal decision making. What that means is that she really could make unilateral decisions. I don't recommend that she obviously make those decisions. Our hope is that we document and we work through a settlement and we try to be reasonable about it. But ultimately, she has the final say until there's a court order changing that.
Yeah, we've been talking about this for 2 weeks in terms of what guys must be doing, and that is being very proactive about daily journals and emails. You can have these phone conversations, but I imagine especially guys who don't have a court order, who don't have a finding that they are officially the father, and a finding of paternity or father-child relationship, should they be having these conversations ongoing, but record them in writing as well, and just kind of confirming the conversation and saying, hey, you've denied me, you're not letting me see my child. I just want to let you know that I'm still wanting, and I'll be willing to do X, Y, and Z. I imagine that's your recommendation.
Yes, I think that's really helpful. I recommend my clients text or email or even call the opposing party to ask for parenting time. In the event the other side says yes, hey, that's great. That's exactly what we want to happen. If the other side says no, then we have a documented record of a parent or a father asking for parenting time and it being denied. I think on a long-term scale, an unreasonable denial of parenting time is not going to look, favorably on the mom for decision-making and parenting time in the future. And possibly a dad could ask for make-up parenting time for this time frame of the mom actually denying him.
So if they have been denied over a period of time for the last couple of weeks, we talked, and I think you alluded to it, and we've heard from the attorneys in California and Maryland, and also in Massachusetts about emergency orders. So if a guy needs to do something, I assume in Arizona there's something that they file the paternity action. Can they seek at least some sort of emergency relief to try to get any resemblance of custody that they once had?
Yes. So the courts have changed some rules to allow emergency or temporary orders that are COVID related. So if the mom is denying on a COVID related issue, we can file those. And I think those hearings are being heard a lot more expeditiously, even without like an underlying normal motion for temporary orders. To your point though, filing a motion for temporary orders will also be good too. That gets the client in the queue for temporary parenting time, even if it's not COVID related. That person will be heard quicker than if we didn't have that. If you're just waiting for a final trial or judgment, I think that's going to take quite a few months for that to be heard. So I think it's a way, depending upon the circumstances, we can do the emergency, possibly an expedited motion contemporary orders or just the standard orders if that's what the client wants. So.
Thanks, Tali. So Andy, in Massachusetts, same thing. Emergency relief, is it available up there? Whether it's divorce, whether you filed a modification, whether it's a paternity, is there some mechanism that the courts in Massachusetts have made available to guys that they can seek some sort of emergency relief in circumstances like this?
Each court has provided a detailed list of each judge's clerk and how you can contact them, but they've also been very specific about the types of things that they want to be heard right now. And if it's not that type of an emergency matter that's quite the level of a restraining order or some type of threat of bodily harm, that you can still be heard, but you need to be very specific and be careful about what you're asking for. I attended a CLE online on Friday where there were actual probate and family law judges speaking to the attorneys. And they were telling us basically that cooperation is the name of the game. And that for those attorneys or those parents who are playing tough and not cooperating with one another or preventing a child from being seen by both parents, that when that person next comes into court before that judge, they're not going to fare well. Because if you think about it, the courts are going to be so backed up, and that judge is going to have such a huge docket that if you have someone in front of, if I was the judge, if I had someone in front of me that was wasting my time because they didn't play nice, they didn't cooperate with the other parent, which ultimately harms that child during this crisis, that make a very lasting impression on me, and I'm not going to forget it. And the judges did everything short of saying exactly that.
Kumada, I mean, I guess what it comes down to, again, we keep talking about it's closed, it's only open for emergency relief, but guys are out there thinking, well, maybe I should just wait. I'll just file when this is all done. Is it more important to take action now from the judge's perspective? In your experience in the court systems in Maryland, do they want to see guys taking advantage of their rights and moving forward? For example, filing a temporary motion, an emergency motion, something that asserts their rights. And what I'm trying to get at is, should guys just wait or should they do something right now?
They definitely should not wait. Doing something right now is important. You can still, in Maryland, you can still e-file, and they've now made it an electronic form of being able to file with the courts in every courthouse as of yesterday. So it's really important to establish, at least with the court, even if you're just doing an initial pleading, a complaint for custody, you're showing the court that right away you're fighting for your rights. They have that. But another important aspect of that is also, and I think this has been touched on some earlier webinars, but also, if there's a child support claim, if you need to make a claim for child support, for instance, child support dates back to the time of filing. So it's important to go and show the court, you're adamant and you filed right away that this is important. I mean, there's a lot with the courts being closed that a judge will have to really look at your case through the file and the pleadings that you file and when you filed it, all the timing and the intricacies. I mean, almost every trial I've ever had, the judge definitely at least familiarizes themselves with the first pleading and the answer to that pleading and any counter pleadings. And so it is very important to make sure you file first. You're showing that you're genuine. There's no point in waiting if there's e-filing available in your jurisdiction.
So that's a good point, really, as we talk about filing now and trying to get that message to the judge, because I think I look at it and I agree, Kumada, that when guys file now, at least they put the other party on notice that they are insisting on their rights. They're making sure that they want something that's fair. And now the opposing party has a period of time to take corrective steps. And I think that the argument for guys would be, I filed 2 weeks ago in the middle of COVID-19. I still tried to get what I wanted, which was just general custody. I tried to make accommodations, and Judge, there's been no response. You see, she still continues 3 weeks later. We're 5 weeks in, and she's still done nothing. I think that really sets the stage for the judge to really get a better picture of the opposing party, don't you think?
Yes, definitely. I think that shows when the courts really don't like it, when you're already showing that you're not cooperating, you're not meeting their deadlines, that you're not taking the process seriously. So showing the court that you are taking the process seriously, that you are adamant about time with your children, that really does speak to the judge when they look through your file before they have to hear your case.
Andy, thanks, Kumna. Though, Andy, let's turn to a topic that is often not discussed, and I think it's so relevant right now because it's probably ripe for abuse. And when I do seminars around the country in person, we do it in front of a room of a couple hundred guys, and I talk about this. I talk about PAS, Parental Alienation Syndrome, and I ask them, do you know what it is? Maybe, and I'm lucky to get 1 out of 150 in a room that know what it is. And so I always give it by example because it's a lofty term, but I think it's so important now because we don't really know what your spouse or your ex is saying to your kids. So maybe you can describe quickly and briefly to guys out there, one, what is PAS and what should they be looking for right now?
PAS stands for Parental Alienation Syndrome. It's where one parent tries to alienate the child's affections and relationship from the other parent. Common examples of that are the parent doesn't tell the child that the other parent called. The parent doesn't tell the other parent that the child has a baseball game or that there's a parent-teacher conference coming up, and trying to exclude or remove that parent from that child's life. If you find that this is happening, and it happens a lot, unfortunately, it's important that you speak to your attorney about this. And also, it's very good to have a therapist involved, and your attorney can help you find a therapist that specializes in working on issues like this. But if this is happening right now, and I know it is to a lot of my clients, the one thing I tell them is that you need to maintain contact. And sometimes a child that has been alienated, it still matters to that child whether or not they're going to admit it now, that when they get a text message from their dad that checking on them in the morning, hey, are you up and dressed? Are you running along? How you doing? And when they go to bed at night, just check on them and say, I love you, bud. And even if they just get a thumbs up back from their child, the message is to that child that I'm still here, I love you, and one day this is all going to be better. So whatever you can do to maintain that contact, and your child, your attorney doesn't, it's very important you talk to your attorney about what the kind of text messages and correspondence you would have with your child, but make sure that you just don't give up because it will get better, and most children eventually do realize who the bad actor was.
I think PAS unchecked is just amazingly destructive in a relationship. And I know you have, and I have, over 26, 27 years I've been practicing now, seeing it rampant in family law. And I always describe it as, especially now, I can imagine what's going on during this COVID-19 where, mom's got custody of the child and dad's trying to get over to see them or call. And the child's like, well, where's dad? Well, your dad's got a new family now, and he's got a new wife and a new girlfriend or a new child. And although he's not here to protect you, I am. That is the classic example of parental alienation that destroys a relationship where mom has almost complete psychological control. So the question is, in that example, I assume Massachusetts courts are very receptive to these types of arguments. I'm asking the judges will be receptive to it, especially when involving experts and therapists and psychologists.
Yes, they are, and they don't like it. The parental alienation syndrome used to be around 5 or 6 years ago. It used to be a much more foreign concept, but now everybody knows about it. All the judges are very used to it. They know it goes on, and again, they don't like it. But if this is happening to you, it's very important that you keep a record of when you are reaching out to your child. Keep your cell phone records so you can say, look, I sent a text message to my child, or better yet, if you're sending a text message to your spouse, your ex-spouse, trying to establish contact, you want to be able to show, look, I sent a text message to this number, this time, consistently, every day. I reached out, and never once was it returned. No one ever reached back. But keeping a log, and right now we're all kept home a lot, this is the time for you to sit down in front of your computer in a Word document. I tell my clients that family law is it's not like contract law where there's a document that's just yes or no with the answer. We have to, as family law attorneys, show a movie to that judge and show your life to that judge's when we're in front of them. Make sure they understand what your life is. And the best way you can do that is keeping a log and keeping a journal and explaining in detail in writing to your attorney what your life, what's going on in your life. Because then when your attorney reads that, it's easier for me to be able to explain to the judge in detail and put some feeling behind it. So all of that is a good use of time right now, and reach out to your attorney, ask them about that, and how you can help them and what they can do for you about this type of thing.
It's good stuff, Andy. Thanks. One of the things I'll tell guys, to wrap up the parental alienation part is, as Andy suggested, maintain contact with your children. That is essential, because as soon as you go for a period of time without that contact, I would just suspect that some form of parental alienation is happening, whether it's extreme or minor. You just need to just jump on it, because maintaining that contact will at least offset it. You'll find out through that conversation perhaps something that's going on. You can take action to correct it. So it's now time to take a very brief break, and we'll be right back after this message with two more panelists. Thanks, Jason and Tali, for joining. We'll look forward to you just in a few seconds. We'll be back right with you with two new panelists.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
Welcome back from our brief break. And now joining us, which new for this week, we wanted to bring even more top attorneys from around the country at Cordell Cordell to you. So now joining us after that brief break, we have Allison Morris in our Miami, Florida offices. Allison, welcome.
Hi, Scott. Thank you for having me today. I'm one of the litigation managers here in Florida. I practice in Miami, but I have practiced all over the state of Florida. I've been with the firm for almost 10 years now, and I've been named a Rising Star by Florida Super Lawyers a number of years in the past.
Thanks, Allison. All joining us as well after the break in Georgia. We wanted to bring some more attorneys from the South to you. We've got Jill Massey. Welcome, Jill.
Hey, Scott. Hey, everyone. I am a senior lead litigator here in the Atlanta office. I've been with the firm for coming up on 8 years. I've been practicing exclusively in family law for those same 8 years. I am also licensed in Kentucky in addition to Georgia. If you are interested in reading or knowing anything else about me, you can grab a copy of Atlanta Attorney at Law magazine that will be coming out later this month. And you can read their feature story on me as an attorney that you will want to watch for 2020. So
that's good, Jill. That's a great accomplishment and award. Let's just start right off with you, because guys have questions. We've been talking for the last 40 plus minutes in kind of around the area of child support, and with 17 million people unemployed now, and we know it's just going to get worse over the next week as those numbers continue to roll in. We're faced with guys watching right now from not only the United States, but the UK, are faced with the issue of paying something. They're out of a job. They are not getting their unemployment yet. They've applied, they're being crushed with these applications. When they may get $3,000 a week, they're getting $400,000 a week. So the question becomes, I want to really focus not just on modifying their child support, but I want you to talk a little bit about contempt and what guys are facing with it. Really explain to them. Maybe we can start there. What is contempt as it relates to child support, and if they're not paying, what is that? And describe that for guys.
Sure. So contempt it's a scary word in and of itself, but it's important to understand what it means before you determine whether or not it is something that should scare you. But everyone knows you have to comply with a court order. Your child support obligation is a court order. If you fail to comply with your court order, if you fail to pay your child support, you could be subject to being held in contempt. And that can come with a number of varying sanctions, and we won't get into all of that, I don't imagine, today. But the important element when talking about contempt is the element of willfulness. You arguably or lawfully should not be held in contempt unless your non-compliance with your child support obligation was willful, meaning you knew you had an obligation and you intentionally did not comply. So that's where the loss of income ties into the willfulness analysis. Did you really have an ability to pay or did you not? That's what the courts are going to have to be looking at as they end up flooded with probably contempt actions due to people not being able to pay right now.
You know, a viewer asked, you know, I'm now unemployed. I don't have any income coming in. I've got to pay child support. How do I stay out of contempt? Am I going to jail? What do I do? What is the best recommendation, kind of a talking point that you can give this guy and many guys just like him to go talk to the lawyer about?
The main thing, at least the main talking point that I would want to convey is that you need to pay what you can. If you say, well, I lost my job, this is an excuse not to pay, it's not going to end well for you. The judge is going to be very aggravated, and he or she is going to lump you in with all of those child support obligors that they've seen in the past that just didn't want to pay for whatever reason. You've got to differentiate yourself from those stereotypical people that have come through the court in the past. When I say pay what you can, that means tap into your resources. If just because your income may be compromised, that does not mean that you're off the hook. If you're sitting on savings, if you're sitting on retirement, if you have assets that have some liquidity, you need to talk to your attorney about how you should go about that, because like I said, no income does not necessarily mean no ability to pay. So the judges are going to look at your actual circumstances, and they're going to have to determine whether your claim of being unable to pay is legitimate or not, or whether you're just making an excuse.
Yeah, and one of the things I think you talk about and you allude to is what other assets do they have that maybe let's just forget about retirement assets. You know, I guess that means, hey, you've got to go see a lawyer right now. We need you to have that conversation, because I'm always about war planning. And that is talking about things and steps you should take before the war begins. We just see this on the horizon. If you can't make the full payment, you got to figure out what you can pay. And I would encourage you, and I imagine you would say the same, in terms of setting an appointment to have a guy, let's go through your finances, let's go through your assets, let's see from the perspective of a judge, based upon your experience, Jill, what are judges going to look at? Are they looking at, is there a savings account? Is there a non-retirement account? What cash is available? Is that what judges will look for in terms of trying to determine what they can pay moving forward?
I think the judges are looking to all available resources and perhaps even extend that conversation to debt. You know, do you have the ability to take a loan to pay your child support? I mean, do you have credit cards that you can advance against? I mean, I know these are not desirable situations, but we're in unique, unprecedented times. So your attorney's done this a million times. They have sat down with someone that owes child support and they have come up with a plan with them. So you might not be thinking about something that might be a pretty obvious scenario that the judge is going to think about. You don't want to go at this alone and be left to your own devices to figure out how to pay your child support. And that's one of my favorite things about this firm is we have so many resources across the country. If I get stumped, I can shoot out a request to hundreds of attorneys across the country and also, in London, and say, what did you do? So get with an attorney. They're going to be able to help you come up with something creative. And that's what you're going to need in this situation that is just completely unheard of up until this point.
Yeah, the wrinkle, I think, in this conversation for us and for guys out there faced with this crisis is this stimulus check that's coming in. You know, it could be $1,200, it could be $2,400, gosh, it could be $3,400, depending upon how many kids you have, your income, and where that check is going, right? And so I guess that's the question of a conversation, you would think, Jill. If that money's coming in, what do we do with it? Where does it go? Who received it? How does it get applied for child support arrearage? How is it to be used? I imagine judges will be looking at the stimulus check as it comes in and who's getting it.
Absolutely. We're getting those questions left and right about which parent it's going to be issued to. If it's going to one parent, does the other parent have a right to any of it? The questions are coming in from all direction. And, this is brand new legislation, of course. So the lawyers we're learning too, day by day. One good thing that we have is most lawyers that practice family law have an accountant that they work with frequently that they can go ask these questions to if they happen to not know the answer themselves. So talking to an attorney is another way to find other resources rather than being out on your own trying to go find an accountant or a tax attorney to talk to. Go to your family law attorney. They're going to have the resources.
If I'm a guy out there, and that is, ask your lawyer, hey, do you have a tax and benefits department that can help me with these questions and answer those, like we do at Cordell Cordell, where we have attorneys who have masters in law or tax who can answer those questions for you, at least provide you with the resources as a support to your attorney that we have around the country. So now that we're on the topic of child support, it really begs the question that many guys are interested in today, especially now with the bad news about the unemployment, and that is Allison out in Florida. Let's talk about child support modification. First and foremost, maybe just give them an update on the courts again. They're open. Can guys file a motion to modify child support right now if they wanted to?
Hi, Scott. It's important to take action and file to modify child support immediately upon any change in circumstance, whether that's temporary or permanent. Really looking at if any order to modify child support can be applied retroactively back to the date you file. But in Florida, we don't have jurisdiction to go back further than the date we file. So it's very important to establish that date of filing, even if you can't get in front of the judge right away. So it keeps you from exposure for any sanctions, including an argument that you're in contempt because you were willfully violating and you chose to not take action. Here in Florida, we do have a number of situations where the courts will find that the fact that you didn't have the ability to pay but chose not to file some type of modification is sufficient to show that you may be in contempt. You didn't take proactive action there. So when looking at whether it's appropriate to modify child support, you want to look at whether it is a temporary change in your income or is it a permanent change in your income. Either one, we can have a type of filing here in Florida, but it's different actions. So is it something where your income is temporarily reduced because of everything going on with COVID-19? Well, in such situations, we can ask for a temporary abatement of your child support obligation. If instead it's a permanent change, you lost your job or unfortunately you're laid off, where your income has been significantly reduced or terminated, then we can seek for a full modification, permanent adjustment of your child support obligation. We can do a modification of child support based on a change of income for either parent. Additionally, it can be looked at for changing the overnight visitation schedule that both parents have. So child support is modifiable under Florida law so long as the difference in the monthly obligation and the amount provided in the guidelines is at least 15% of that monthly amount or at least $50. So it's not a huge requirement in order to make that modification. But if you have any questions about that, please talk to your attorney or contact one of us so that we can really give you an analysis. Is this something that we need to proactively file to make sure you're protected not only from sanctions or a contempt argument, but also to make sure that we get an adjustment that is retroactive back to the date we file?
So I think that's a point that we don't want to kind of gloss over, which is the retroactivity, Allison, and that is so important, especially for guys right now who have suffered a job loss and they don't know what the future holds. They're not just furloughed, they may have been laid off. And so that is what we're trying to really explain, is that retroactivity. And so as you explained it, is that the courts only have the ability to go back to the date of filing. And so if guys wait, that child support is going to continue to accrue. Is that right?
That's absolutely true. In Florida, we are unable to ask the judge to go back any further than the date that it was initially filed to modify. The only exception would be a change in time sharing. That's a different situation. But if it's based on a change in either of the parent's income, the court only is able to go back to the date of filing. So it doesn't matter how fair that is or how much you may want to, you may have a strong argument otherwise, the judge can only change it back to that date of filing. So it is very essential that we get it filed right away.
Let me go up to you, Andy. I know you are licensed in Massachusetts, New Hampshire, and Georgia, like Jill, but I mean, kind of that perspective in terms of retroactive filing, is that as well applicable in the states where you are, that it's tied to the date of filing, or is it a different standard for guys who are looking to modify their child support?
Usually, it's the date of service. So what we've been doing is we'll get something filed, like I've got several notifications actually, so I just filed, and I get the summons back, because the clerk's offices are still issuing summons here in Massachusetts. And what you do is, what we have it are given to our private constable, and once we have the recipient served, you can ask for retroactivity back to the date of service. But the important thing is to take action and to get that modification action filed, or get that motion for temporary orders filed. Because if you have a divorce pending, then, data filing would apply in that case. It's a new case. If it's a new action about modification of alimony or child support, that's date of service. That's the distinction between the two.
Kumada, let me go to you in terms of retroactivity in Maryland. What is the standard there in terms of guys seeking relief? Do they look to service? Do they look to filing? Is that even relevant? Can they get retroactive child support?
Yes, they can. And it goes back to the date of filing. So as soon as you file your pleading, that's as far back as you can go. So, if you're the primary parent, you know that you will be entitled to child support. It's important to start filing now, because it just goes back to the date that you filed that pleading.
So Allison, in terms of a guy, let's say they filed, they're taking your recommendation, getting it on file, at least setting that standard for future retroactivity. Is there something that guys can file in an emergency motion or a temporary motion to give them some relief now with a massive child support obligation when they have no resources and no income coming in the state of Florida?
Absolutely. So we can file the modification petition, and then we can also seek temporary relief, either in the form of a motion for a temporary abatement of the child support, meaning we can stop it for a temporary period, or a temporary reduction. So there are definitely options. And in Florida, it is going county by county as far as how the courts are handling hearings. But a lot of the judges are still hearing by Zoom and telephone hearings. So we are still able to get in front of the judges on a temporary basis for things like that.
Are you recommending guys to just be proactive, have a conversation with their ex-spouse about the child support amount? Or at least is there value for guys to do that before they file and get it in writing?
Well, certainly, I think that the lines of communication, it's always beneficial to keep those lines of communication with your former spouse open, if at all possible. But from a legal perspective, it doesn't have the weight that we would want it to. The filing is the essential part. If you don't file, even if you have documentation that you showed your former spouse months ago that you didn't have the ability to pay child support, legally the judge still has no ability to go retroactively back. So the filing is the essential date, but certainly I would still encourage any client to have those lines of communication open with their former spouse and let them know, this is the situation I'm in, this is what I'm going to try to do. I completely agree with Jill in that making good faith payments is important, even if that's $10, even if that's $50. It doesn't have to be everything that you owe, but trying to make good faith payments, communicating with your spouse, it all shows good faith. So I would recommend that in addition to the filing.
So I know that we talked briefly about the stimulus, that COVID stimulus money that's coming in. What are you hearing in Florida? Are judges looking to that as a resource for guys to use to help pay child support when they need it for their own expenses, but they have no other income to try to meet some child support obligation?
Courts aren't expecting everybody to just deplete that money, but certainly from a good faith perspective, if they are getting some money, they should make sure that their children are supported too. I mean, the idea of child support is to make sure your children are being fed and that they're being taken care of. So make sure you are in good faith providing some of that, but I don't think that the courts are expecting all of that money to go directly to child support.
Thanks, Allison, and thank you to all of our panelists today. That wraps it up for this week's version of our live webinar dealing with COVID-19 and its impact to guys going through divorce, considering divorce, modifications, as we've talked about, even paternities, guys trying to establish that father-child relationship. So I would encourage you to check us out on the web at CordellCordell.com. If you want to take advantage of a consultation, you had some questions today. You have further questions, contact us at 866-DADS-LAW, or again, you can reach out to us at CordellCordell.com. Encourage you to continue to submit your questions. We'll address those questions on my daily podcast that you can find on men's divorce. And remember, that email address is coronavirus.divorce@CordellLaw.com. Again, thanks for joining us. Look forward to seeing you next week as we continue this series dealing with COVID-19 as it relates to divorce. Until next time.